My name is Jose Moya. I'm the director of the Forum on Migration, and it's a great pleasure for me to welcome David FitzGerald. I have known David since he was 4 years old, or it feels that way. We were together at UCLA. I was a professor there. He was a student working on his PhD. And he's currently a professor of sociology at the University of California in San Diego. He's also the director of Institute for the Comparative Studies of Immigrations. He has been very active in Mexican and U.S. border issues, also in California. Although he's by training a sociologist, he's very historical in his research. His first book actually was a look at Mexican migration from the point of view of Mexico. And it included both policies and public discourses, but also an ethnographic, so you're also an anthropologist, an ethnographic study of this Alto de Jalisco, this micro-region within Jalisco, that was a major center of migrants to the United States. Then he has also done a book with a fellow Bruin from UCLA. He was a fellow student, Martin Cook, David Cook Martin. They co-wrote a book about, 5 years ago? Studying policies, migration policies throughout the Americas, and actually showing an inverse relationship to democratic liberal regimes. The more democratic and liberal, the more xenophobic their policies were, which seems incongruous, it seems surprising, but maybe it's not, because a lot of this was because of public demand. And then he's written about many other things, but it came out, the book already? Yes. Oh, when did it come out?
In the spring.
Oh, okay, so it's already a few months old. This is a study of how liberal democracies in the West, in Europe, in the United States, are trying to prevent inflows of people through means that are semi-legal, at least by international law standards. Well, in the case of the United States, forcing Mexico to block Central Americans from crossing into Mexico. In the case of Spaniards are doing the same with Morocco. The Italian government was paying the Libyan army, which is also connected to mafias and to organized crime, to prevent sub-Saharan Africans from entering. So that's the topic of his book and his presentation today. Is very timely. As we speak, this is happening. So it is a great pleasure and an honor to have you.
Well, thanks very much, Jose, and thanks also to Daniel for co-sponsoring. It's a delight to be back in this room. This is the second time that I've had the opportunity to address this forum, as I talked about my previous book, Calling the Masses. Today, the work that I want to talk about is ripped from the headlines, and this was a book that was very difficult to finish because in all of the cases that I was looking at in the US, Canada, Australia, the European Union, every week, sometimes every day, there was some kind of new development. And there have even been developments in the last 24 hours that are highly relevant to what we're going to be talking about today. But my main goal at the beginning here is to give a historical and a comparative perspective to give some background and some understanding to these issues that you wouldn't get simply by watching the television news or even by reading high-quality newspapers. And to continue to try to establish my historical bona fides, even though I'm actually just a sociologist, I'm going to start out in ancient Greece. So asylum, like many ideas, it's a Greek word. It comes from the Greek. And there are many traditions of asylum, but the one that's most directly related to the contemporary version of asylum comes from classical Greece. And in the classical period, every temple in Greece was considered a sanctuary where people could come and ask for asylum based on various grounds. And they weren't necessarily given asylum, but they had the chance to go and present their case, suggest why they should be granted asylum. And here in this representation, which comes from a Greek amphora, you can see two people who are sitting on the altar here. And they're asking for asylum by holding up this little branch as part of the symbol. And you can see that from the outset that this was a highly territorialized concept, that space really matters, because here these people are almost like a game of safe because you're touching base. But just to the side, you see men with their unsheathed swords, ready to do them harm if they step off base. And just to get into that space was controlled in some period. So for example, the police in Athens put up a checkpoint at the entrance to the Acropolis to try to deter unwanted asylum seekers from going into the temples within. So there were efforts to control asylum, but the idea of asylum really meant something. And of the many historical examples of people fleeing war being granted safety according to the asylum system, we can look as one example from the island of Kos. So Kos is just across the water from Asia Minor. This is contemporary Turkey here, condos on the Turkish peninsula of Bodrum. And in 88 BCE, the Roman historian Tacitus records people who were Roman citizens living in Asia Minor, fleeing to Kos and finding sanctuary in the temple there, which had been founded by Hippocrates. Well, if you have some kind of associations with Kos in the context of refugees, it's probably because in 2015, this became one of the major conduits of Syrian and other refugees trying to find sanctuary in Europe. And this is where the boy Alan Kurdi, a Syrian Kurd, and his mother and sibling died trying to cross these narrow waters. Their bodies washed up on a beach in Turkey. And these images, there are other images that are more strong than this, really became the human face of the Syrian refugee and European crisis. So it's ironic that this happened in the very same place where Hippocrates founded this sanctuary, this healing temple, because the same logic that we see in efforts to keep out asylum seekers from Greece, you can see in other ideas, such as the Hippocratic, the operation of the Hippocratic Oath. So let me explain. The sociologist Alejandro Portes and his colleagues have developed this idea of a Hippocratic bubble to look at a different context, but I think it's highly revealing. And in that context, they're looking at the US healthcare system. So the United States famously does not have universal health care, but physicians have taken the Hippocratic Oath that they will provide assistance to those in front of them who require assistance. This is a basic part of becoming a doctor. It's a very strong norm. So what do hospitals do to try to control, to try to manage who comes into the space of the physicians? Well, sometimes there are security guards, including armed security guards, that keep just anyone from barging in and demanding medical services. That's usually not what happens, though. Usually you have clerks who are smiling, they're very polite, they ask for your identification documents, they ask to see your insurance card. But whether it's the strong face or the smiling face, the result is the same: to control access to a space where a norm to provide aid is activated. Hence this idea that they have of a Hippocratic bubble around the oath. So the oath really means something, but it's very difficult and deliberately difficult to get into that space. So we see this with asylum and efforts by states to circumvent the basic norm that underlies the contemporary asylum system. And that's the norm of non-refoulement, the norm that people who are being persecuted on specific grounds which are laid out in international law and also in domestic law, the people who are fleeing persecution based on those grounds will not be turned back into the arms of their persecutors. And this is a very strong norm. It's not universal, but it's very strong. It's written into the 51 Refugee Convention and its 67 Protocol. 148 countries around the world have become party to this convention or the protocol, including the United States. There's an even stronger version in the Convention Against Torture, dating back to 1984, with more signatories, that people who would be tortured, regardless of the reason, cannot be turned back into the arms of their torturers. So it's not just that you would be tortured because of your race, religion, national origin, membership in a particular social group, or political opinion, regardless of the ground, that you cannot be refouled. So the theoretical question that I set out to answer here is, how is it that organizations, and the state is an organization, how is it that organizations try to evade norms that they have explicitly signed onto, norms which do really mean something, not all the time, but they often mean something in practice. They accept those norms, but how do they try to evade the deeper meaning behind those laws? And then what constrains the efforts of governments to evade those norms and those laws? And the cases that I'll be talking about, although in Q&A I'm happy to talk about other cases as well, but the cases that form the basis of the book are the US, Canada, Australia, the countries of the European Union, although because I'm also looking at the countries that they use as buffer states, it very quickly expands to encompass much of the planet. All right, so there are two different ways that states try to evade the asylum regime. And they do that by manipulating territoriality. And they manipulate territoriality in these two different but linked directions. So the first is through what the late Ari Sulzberger, the political scientist Ari Sulzberger, called remote control. He wrote very persuasively and generatively of the idea of remote control, in which states try to push their territorial control outward, often thousands of kilometers away. So, and what he was writing about was the advent of controls on passengers crossing the North Atlantic, so that by the late 19th century, someone trying to come to New York, say, would have to first clear some kind of controls in a European port of embarkation like Hamburg. So that's a phase of extraterritorialization, of pushing border control far out beyond the territory. But at the same time, and for a related reason, states are making these very fine distinctions in space, this hyper-territorial distinction in space. So on the one hand, border control can be pushed out literally thousands of kilometers. Just last year, I flew from Abu Dhabi to JFK, and I passed US Customs and Passport Control in Abu Dhabi. So pushing it out however many thousands of kilometers that is. And at the same time, they're making these very micro distinctions because the legal significance of stepping your foot onto a particular territory is really important, that generates all kinds of, or activates all kinds of rights. Those rights may be rooted in the civil rights of the US Constitution or another constitution. They may be rooted in the system of non-refoulement, that people will not be returned. But to not be returned, you first have to be someplace not to be returned. So you can see this hyper-territorialization very visibly right now in politics in many places, including at the US-Mexico border, where I live and work. So at that border, it's very clear whether or not you are in the US or in Mexico. And as you cross, also it's very clear with your cell phone. They know exactly where you are and when to start cranking up the charges. So what's happening all along the US border with Mexico, where there's a land border or a bridge, is that US agents or their private security guards are putting their boots right here on the line to literally prevent someone who's asking for asylum from stepping foot into the US. This is an image taken by a Getty photographer, John Moore. This is right where I live in San Isidro, which is the San Diego-Tijuana border. And you can see this is the borderline right here. And so this is new, actually. And this is not the full passport control where your documents and all of the normal questions are asked. This is before you ever even get there. This is just to try to enter the US an inch. And you have to show your US passport or show a US visa. And then if they're satisfied, you go in and then you have a much more full screening. Governments try so hard to prevent people from touching their toe into a particular space, also because other rights are activated in those spaces, as I said, by the Constitution. There are many different cases going on right now being litigated in the courts around cross-border shooting cases. These are cases where a US Border Patrol officer fires, usually he, fires his weapon on US soil. The bullet crosses the border at high velocity, strikes someone on the Mexican side, and that person dies. And so there are a number of different legal questions, but one of them is, has the constitutional rights of the person killed on the Mexican side been violated? if they were never on US soil. The bullet traveled across, but they were not on US soil. And these questions have also come down to defining exactly where did these bodies fall. So in one case, a few years ago in San Diego, we'll show you a photo. It's a strong, very harsh photo in a moment. But in this case, there was a Border Patrol officer who was in an altercation with a Mexican national. The Border Patrol officer fired. The Mexican national's body fell across the borderline. And the US government hired a surveyor who drew a yellow line through the body, determined that the head, which is what sustained the wound that killed this man, that the head had fallen on the Mexican side. So even though his feet were on the US side, that he didn't have any constitutional rights that might have been violated. So when I'm talking about micro distinctions in space, I'm talking about fractions of an inch in this case of Jose Alfredo Yanez Reyes. Okay, so these are the stakes. This is what governments are doing, but they're not able to always do willy-nilly what they would like to do. And the executive is not able to always willy-nilly do what it would like to do in this regard. So the different kinds of constraints on the states varies across the state. It varies across time. It varies by specific technique of remote control. And there are different sources of these major constraints. One of them is the courts, the supranational courts in the singular case of the EU, as well as national courts. But there's a lot of variation here. For example, Australia does not have a Bill of Rights, which was news to me when I started this project. The only major democracy without a Bill of Rights. That means that the judiciary has been really hands-off when it comes to any kinds of rights of asylum seekers. And you can see that translate into much harsher policies which would not be able to pass muster in the other cases that I'm looking at. Another source of constraint is transnational advocacy networks, which combine organizations like the UNHCR and civil rights organizations, journalists, even parts of the state. For example, the US State Department monitors human rights violations around the world. So there are parts of the state that are also very concerned with these things. And particular techniques that I'll highlight when I go through them, these advocacy networks have been an important, they've created important limitations. And then there are also foreign policy linkages because governments have many different interests. The interests of controlling asylum flows become linked to controlling all other kinds of migration flows or tourism flows or commerce and other issues that may not have nothing to do with mobility per se. So if you survey the other people have written about these questions, and if you survey those studies, the vast majority of them suggest that this system of remote control of asylum seekers is something that began, depending on the case, in the 1980s or the 1990s. But in fact, every single one of the major techniques of remote control that are used today were used to try to contain Jews fleeing Nazi persecution in Europe and prevent them from reaching the Americas or Palestine or liberal European states. So I don't have time in this presentation to go through all of these. I'm happy to talk about this in Q&A. But every single one of these techniques that you find today, you can also find during that early period. And I developed that in the text of the book. There are some new things under the sun. What's different now is that rather than having a system that is targeting a single group, you have a global system that affects all asylum seekers, whether it's targeting a particular group or not. The effect is that anyone trying to seek asylum is affected by this system. You have what I call an architecture of repulsion, based on a set of techniques, and I'll go through these in detail for the bulk of my presentation to try to keep asylum seekers away. And the result is that it's extremely difficult for someone who is seeking asylum to reach a place of sanctuary legally. The resettlement option, which if you follow the news at all, you'll know that the resettlement options in the US are being slashed under the Trump administration. Stephen Miller has said that he wishes that the number were 0. But even before that, even if you go back to, say, the days of the Obama administration, if you look around the world, resettled refugees are never even 1% of the world's refugees. So it's a really small number of refugees that take part in that program and 30-some countries that have resettlement programs. The vast majority are never going to be eligible for diplomatic asylum in a place where they would go to, say, a US embassy abroad and ask for asylum. That's really something that only affects a handful of high-profile dissidents historically, not kind of run-of-the-mill folks who are seeking refuge from persecution. So that leaves you with an effort to travel, often illegally because there is no legal way, and reach one of these territories to ask for asylum. This architecture of repulsion comes from many different sources, some of them designed to affect asylum seekers, all of which affect asylum seekers. And the functions of these structures are very tightly interwoven. So in any one piece, sort of maritime interception by itself makes no sense if there's not some space where people are taken where they have fewer rights, for example. So we'll show how these things are working together. And then there is a global circulation of ideas about how to control asylum seekers, of intelligence information about smuggling networks, of the capacity to control mobility, training of officers, and so on. All of these things are flowing around the globe, often behind the scenes, but nevertheless, there is this global circulation that makes it truly a system. Okay, so let's get into the actual empirical meat here. What do I mean by these different pieces of this architecture of repulsion? So the first is a cage. And the cage is an effort to contain potential asylum seekers or refugees in their country of origin, or in almost physically a cage sometimes, camps, in usually neighboring countries. And in the image here, you can see a satellite image of the Satri camp, the most prominent camp of Syrian refugees in Jordan. And here, the architecture of repulsion is part of the architecture of protection. The architecture of protection is a term that's been around in this field for some time because the UNHCR and its implementing partners provide this life-saving services to people in these spaces, right? So that they're not killed, so that they have access to basic services, healthcare, food, water, and a lot of camps as they have become sustained over time, education, and so forth. And so that's happening at the same time. There really is protection, but it's also an effort to keep people there as opposed to continuing to migrate to the rich democracies. And this is no secret to people who work in this area. The vast majority of the UNHCR funding, even today under Trump, more than a third of it comes from the US, and all the other major donors are the rich liberal democracies. More recently, you see some of the Gulf states moving in there, but it's still the case that these are rich liberal democracies who are in what some have called a grand bargain, where in return for most refugees being bottled up in places like Jordan and Turkey and Lebanon, those efforts will be funded by the rich democracies so that they will not be, so those refugees will not reach the shores of Europe, most particularly here. Then another technique, and it's the hardest technique of caging, is military intervention. And since the 1990s, there are a number of prominent examples of governments, usually the US, sometimes European allies, sometimes Canada and Australia as well, explicitly using military force to prevent refugee outflows. And so on the screen, you can see one such example from Haiti, but there are other examples from Bosnia, from Kosovo, from Libya, Kurdistan, and so forth. Another technique of caging is what the Australians have done with an idiosyncratic system of what they call offshore processing. The exact details around offshore processing have changed over the years. There have been a number of different versions, but the bottom line is that since 2001, when asylum seekers trying to reach Australia, passing through usually Indonesia, would be intercepted at sea, they were taken to Manus Island in Papua New Guinea and the Republic of Nauru, the world's smallest island republic, for processing to determine whether or not they were refugees. It turns out that the vast majority of those who've been through processing have been found to be refugees according to the international criteria. What's unusual about this system is that the people who were taken to those islands didn't pass through there on their way to Australia. It's kind of a gulag system in a way. And this is a model that a lot of other governments have looked at and think that is a good thing. So the European governments have often looked at this. This is something that the Americans have looked at. The system itself is a different version of what the US has done in places like Guantanamo. So it's another example of how there's this circulation of ideas, but then they also morph into local circumstances in different ways. All of the governments that I'm talking about also use publicity campaigns, propaganda campaigns, if you will, with the stated goal of trying to convince people not to leave their countries of origin or to pass through countries of transit in the first place, highlighting the dangers in those places. So in this one, this is a graphic novel that the Australian government distributed in Afghanistan, showing this guy here who tried to get to Australia, was intercepted at sea, taken to this godforsaken island, holding pen indefinitely. And at the end of the comic book, graphic novel, he's completely depressed and he's wishing that he were back with his family, enjoying the party back in Afghanistan. The US has a number of similar campaigns that are presented as if they were made locally, but they're actually paid for by the US government. Okay, so what are the limitations on this kind of technology or structure of the cage? Well, it looks bad to both international and domestic audiences if a government like the US is openly cooperating with persecuting governments. And so this has been especially an issue in the US-Cuba relationship since the early 1960s and the management of flows of Cubans to the US. It also has been an issue. I'll stick with that same example. There's a whole chapter on the Cuba-US situation. It gives a lot of leverage to governments that are in unfriendly relationships, in this case with the US. So certainly when Fidel Castro was still in charge in Cuba, he was very adept at using the opening and closing of ports like Mariel and others before that to apply pressure on the US to get other things out of that hostile relationship. It's also extraordinarily expensive, and if you look at the Australian system, for example, they've spent many times more to maintain people in Nauru and Manus Island than if they had simply brought them to Australia. It's kind of like the death penalty in a way, where the death penalty is much more expensive than, well, anyway, I'll leave it with that. Very expensive. So the next technique is the dome of creating a virtual dome over not just a country, but an entire continent to control air travel. And this is really the most important structure. It's the one that is the least visible, and it's the one that affects the most people. So this has a number of different subcomponents here in this pen, which is like a lapel pin of the US preclearance operations. The US maintains preclearance operations in about 15 airports around the world. Most of them are in Canada, but also I mentioned Abu Dhabi, and there are a couple in Ireland and so on, where people who are traveling to the US interface with US customs and passport control in those foreign airports. And you can't ask for asylum in those spaces, but the US selectively turns on its jurisdiction. So for example, the Department of Justice has prosecuted people for smuggling in those spaces, but then says that US immigration law, Immigration and Nationality Act, does not apply in those spaces. So they selectively play with which laws apply in those spaces. And this is, preclearance operations have been around since 1952 in the air system, beginning in Toronto. But this, like most features of the aerial dome, have much deeper historical roots. So the US has had preclearance operations for sea passengers from Europe trying to reach the US, going back to the late 19th century, actually, and US preclearance operations in Canada. Carrier sanctions are another major technique where air carriers, or before that, going back to the 19th century again, passenger ship owners and captains are liable to pay fines if they transport inadmissible passengers, and they're also responsible for taking that passenger back to the port of embarkation. So the vast majority of the work of remote control is not done by government agents. It's done by the airline clerks at the check-in in Bangkok or Istanbul or some other foreign airport. And there's not a legal deputization of those people, but in practice, the incentives have been deliberately created such that they are going to do the work of remote control. Visa policy, you might take it for granted that if you want to travel to a lot of countries that you have to get a visa in advance. That's a very new idea historically. That's an idea that's only about 100 years old, that you would need a visa in advance of going to another country. And when those documentary restrictions were first created around World War I, a lot of people were outraged. When the war ended, this was an emergency wartime measure. Well, the war ended a long time ago and we still have these measures. So these kinds of control measures become institutionalized and they accrete. They become very difficult to take away even though the original conditions have ended. And a lot of people were outraged at the time that they were subjected to treatment of common criminals, to have their photographs taken. This is something that Jose has studied, I know, in the context of the Paris police and Argentina and so on. But people thought, how is it that I'm just a traveler? I'm just trying to go to another country to look around. Why should I have my photograph and my fingerprints taken and all these intimate details about my life written in this book? But now we're all used to it. If you look at the countries around the world that are the most restricted in terms of countries that you can visit without a visa, the most restricted nationalities are all the major countries of asylum seeking. So if you're from Syria, if you're from Afghanistan, South Sudan, Sudan, Iraq, and so on, there are very few countries, on average maybe 30 countries for that group that I just mentioned, that will allow you to go without a visa. By comparison, if you're from Germany, it's more or less 180 countries that you can visit without a visa in advance. So then there's a lot of coordination with buffer countries. A lot of this coordination takes place behind the scenes. A lot of this has to do with the securitization of air travel. So for example, if you were flying from anywhere in the world to Canada, all of your information is shared with the US authorities before you ever arrive in Canada. And the same is true of Mexico, which is not widely known in Mexico. And there's a reason why it's not widely known in Mexico. That would be considered very politically sensitive. But if you're flying, say, from Madrid to Mexico City, and that's your final destination, you still have all of your information shared with the US authorities beforehand. US has very effectively applied pressure on Mexico going back to the 1980s to impose visa restrictions, again, for people trying to go to Mexico, on particular nationalities where there's an expectation that at least some of them will continue on to the US. I had a grad student working in Mexico City on this issue, and she was actually in the Ministry of the Interior with someone on the phone with Washington who was getting the thumbs up and the thumbs down on particular passengers and visa seekers. Okay, there are very few limitations on this aerial dome. We have come to take for granted that we have to deal with these kinds of restrictions when we travel. There's no reason to think that air travel will ever become desecuritized. This is, I think, a permanent feature. Even before 9/11, this was, going back to the 70s, this was a feature of air travel. And from the perspective of asylum policy, the people who were harmed, the person who was fleeing persecution and can't get a visa from the US consulate or the Canadian consulate, the person who is denied boarding at the airport because they don't have the right papers, or because there's a liaison officer that says, don't let that passenger board. We don't see them. We don't even know how many of them there are. The governments, I think deliberately probably, don't collect statistics usually on denied boardings. Even when they do collect statistics, this is a very, very low priority, and they don't systematically do it. So the people who are harmed are not ending up on television. We don't have images like we have of Alan Kurdi, the Syrian Kurdish child on the beach, of somebody who was denied boarding and then maybe killed by their persecutors. So that makes it very hard for advocates to fight against this system. Okay, let's talk about the Moat. The Moat now, the idea of maritime interception and other activities on the water. And here in the image, this is a patch worn by a multi-agency US task force. It's called Operation Vigilant Sentry, to prepare for the possibility of another mass outflow from the Caribbean. Think of the 1980 Mariel boat lift, for example. And here you can see the talons of Uncle Sam the Eagle coming down over Jose's home island of Cuba and the Dominican Republic and Haiti here. So the scale of interceptions in the Caribbean is much larger than I ever would have guessed before I started this project. From 1982 to 2015, which is when I was writing this up, 250,000 people had been intercepted by the US Coast Guard in the Caribbean. How many of these were sociologically refugees? How many of these would have been paroled into the US or given some kind of asylum had they made it? Nobody knows. So I'm not making any claims about what percentage of these people were refugees. Certainly some of them were, and many of them would have tried. And what's interesting about this program is that when it was first put into effect under the Reagan administration, the executive order very explicitly said that when the US Coast Guard intercepted people on the high seas, that it would not refoul them. Even though that was, high seas means outside of US territorial waters, that the US would fulfill its obligations under the Immigration and Nationality Act and being party to the 67 Protocol, not to refoul people even on the high seas. Well, there were two big spikes here in interceptions, and the first one here is in 92, primarily of Haitian nationals. And so a new executive order was issued under the first George H. Bush, that the US was not obliged under domestic or international law to apply the provisions of non-refoulement, that it could do that at its discretion, but it no longer considered itself to have been obliged. So a long-standing interpretation of the law was, turned over just in an instant. Many advocates complained. There was a lawsuit. This went all the way to the Supreme Court. And in a case that is still the law of the land, in the Sale case, the Supreme Court ruled that the US government was not obliged to follow that principle of non-refoulement outside of its territory, such as in international waters. So I've never met an immigration lawyer who thinks that that was a good decision, but that was the decision. That is the current law of the land. Sociologically interesting is that despite the fact that the courts there gave the government apparently carte blanche to do what they wanted to do on the high seas, in practice there have been a number of tests to determine whether or not people might have an asylum case at sea. And for all nationalities but two, and I'll talk about that in a second, there was the so-called Scheldt Tests. I think this is Bill Frelick's term originally. And so the idea of the Scheldt Test is if you're in this situation, this is a photograph of a Coast Guard vessel that's intercepted a number of Haitian nationals. They're on the deck. They're being repatriated back to Haiti. So if you were to suddenly, if this person were to suddenly jump up and say, hey, don't take me back. I fear that I'm going to be persecuted based on my political opinion if you take me back. Then there would be, at the time, an INS, or later DHS officer, seconded to the Coast Guard, who would do a preliminary interview, and if the person passed that preliminary credible fear interview, that person would be taken to Guantanamo Bay, to the US Naval Station for further screening. But there was no systematic screening. People weren't asked, hey, why are you on this sailboat, and so forth. So by any legal standard, this is minimal, but it's interesting that it even existed at all. And talking to people who were in the Coast Guard at the time, they said that they were trained, and I think this is still the case, they were trained not to interact with the passengers any more than was absolutely necessary to get people on and off the boat and provide basic food and water and things like this, so that they would not hear. It's kind of a see no evil, hear no evil situation, so they would not easily hear a claim. Okay, so there have been a couple of exceptions. One was an exception going back to the 90s for nationals of the People's Republic of China who were administered a 4-question questionnaire about the reasons for their leaving, what would happen if they went back. And the other famously was for Cubans from the mid-1990s until the very last days of the Obama administration in January 2017. And from the perspective of understanding how territory is manipulated, the Cuban case is exceptionally interesting. It's also discussed erroneously in almost every reference. So let me spend just a couple of minutes on this. The so-called wet foot, dry foot policy, you can scour US law and you will never find a wet foot, dry foot law. So this is the combination of a statute, an INS memorandum to interpret that statute, a bilateral arrangement with the Cuban government, and then some evolving norms. The wet foot part is that according to a 1994 agreement between Washington and Havana, that Havana would accept the repatriation of Cuban nationals intercepted at sea, who had been interdicted in international waters or even in U.S. waters. This is important. This includes people who were interdicted in U.S. territorial waters. And this was not part of the bilateral agreement, but in practice, the U.S. had this shipboard credible fear screening process for Cuban nationals at sea. So that's the wet foot part of the agreement. That's what went away under, that's the part that still exists apparently under the Trump administration, at least from what we know from the first part. The dry foot part is what has been eliminated under Obama, and it continues to be eliminated. And so this was an interpretation going back to the Cuban Adjustment Act, but the interpretation comes in the mid-1990s. Importantly, that if Cubans have reached U.S. dry land, that they would be normally paroled into the U.S., except in some rare cases when they were considered inadmissible because they had committed serious crimes or something. But in most cases, be paroled into the U.S. within a year, would have a green card and be living in the U.S. freely. So this concept of dry land is interesting here. This is not about U.S. territory. This is dry land, which is a weird concept that you don't find in other areas of the law. What counts as dry land? Well, there are a number of kind of Kafkaesque cases around this with really serious implications as to whether or not people would be able to be paroled into the U.S. or not. So this is just one case from 3 years ago where a group of about 20 Cuban nationals reached this lighthouse. Everyone agreed that this lighthouse was in U.S. territorial waters. It's in the Florida Keys on a reef. There's about 6 feet of water between the bottom of the lighthouse and the reef. And this is an image taken from a TV helicopter. You can see this is a group of the Cubans who were asking for to be paroled into the U.S. Here's a U.S. Coast Guard vessel, and there was another vessel. And so this was litigated in the courts where, does this count as U.S. dry land? And the court said, no, this doesn't count because to reach another island, you would have to swim. There were some similar cases around a piece of a bridge that was disconnected from a newer bridge to decide whether or not that counted as dry land. Lots of different cases around this where, again, these really micro distinctions in space matter, and that's why they're so aggressively patrolled. The European Union, this is something that Jose mentioned, the European Union as well as its member states has also been very aggressive about remote control, not just in the Mediterranean, but their original missions organized by Frontex, their border control coordinating agency, were off the coast of West Africa, very, very far from places, Mauritania and so on, very far from the coast of Europe. But here the courts, and specifically the European Court of Human Rights, has been an effective constraint on refoulement from the high seas, because the Italian government for a period was intercepting people bound for Italy and forcing them back to Libya. And it wasn't just the Italians. They were doing that with the assistance, for example, of German helicopters that were being used within a Frontex operation. So this is not just Italy alone. Well, the European Court of Human Rights said that that was illegal because even though this happened in international waters, that Italy had effective jurisdiction over the people on this boat who had no other choice but to follow the orders of the Italian authorities and so forth. But the Italian solution, as Jose began to suggest in his opening remarks, the Italian solution has been to pay the same smugglers that yesterday were smuggling people to Italy to do the dirty work of containing them in Italy, in Libya, to prevent them from crossing the desert borders into Libya. The Libyan Coast Guard is financed and trained by the EU and specifically Italy, and has been for a long time. And to bring people back to Libya where they've been held in really horrific circumstances. If you can see these things on CNN of people literally being sold into slavery, of some really horrific forms of torture, and so on. So this is all being done at the behest of Europe. Okay, so what are the limitations, though, and at least on the high seas in terms of these kind of techniques? Well, there has been some minimal monitoring by NGOs. It's very difficult to do. This is a space that lends itself to action by navies rather than NGOs. But specifically in the Mediterranean, and this is going back much more than a decade, you've had a number of NGOs that have bought their own or hired their own boats to go and rescue people at sea. And it's a rescue mission, but it's also a monitoring mission. The idea being that governments are less likely to simply let people die in the water if they're going to be found out. That's part of the logic that the NGOs very explicitly deploy. And a number of coastal state governments, and the Italians have been exceptionally aggressive in this case as well, have tried to shut down the operations of the NGOs by criminalizing their activities, by saying that that's actually people smuggling to get someone out of the water who's about to drown and bring them to Italy or Malta or Spain or somewhere. And so there is a new draconian law that fines the boat captains of these operations, something like €1 million, efforts to prosecute. All of this stuff is being litigated as we speak. But the bottom line is that rescue ships that were responsible for the majority of rescues in the central Mediterranean as of a couple of years ago are not being allowed to operate anymore. In Australia, it's exceptionally difficult for NGOs to find out what's going on because the government is completely secret about what they call on-water operations and will not even share really basic information about what happens with other parts of the government, like the Senate. Okay, another limitation here is it's not so much the law, I think, but a more diffuse humanitarian norm that particularly when people are allowed to drown, that there is something wrong with that. And it's also yielded some very grotesque images, which I think are activating that humanitarian norm. And as a practical matter for the governments that are trying to prevent asylum seekers from coming, if people are intercepted at sea, then what does the government do with them? If they simply transport them to the destination, which has happened a lot, then the logic of interception falls apart. And so governments look around and they try to find collaborating states, whether it's the coastal states like Libya, to the extent that that's a state, or countries that will do offshore processing like Nauru and Papua New Guinea. And often we look at the examples that have been successful in the terms of the policymakers themselves, but we forget that a lot of times governments can't get what they want. So Australia has approached many different governments to try to get them to do offshore processing, and most of them said no. Most of them said no. So 2 said yes, and those are the ones where that happens. But so the processing system is contingent on that kind of collaboration, and then it's very difficult to get other countries, third countries, to accept the resettlement of people. And we can talk about resettlement from Nauru if anyone's interested in Q&A. Okay, moving ahead to the buffer. All of these countries tried to use their neighbors and then concentric rings of neighbors as buffer states. This is something that's very much in the news right now in the context of the US, Mexico, and Central America. But it's been going on for a long time. So since the early 1980s, the US has been very active about using Mexico as a buffer. It hasn't publicly used those words because that's impolite diplomatically. It provokes a reaction in Mexico. Historically, when the US has been too vocal talking about paying for deportations of third country nationals from Mexico, for example, the Mexican government has not cooperated as much. They have been very happy to cooperate behind the scenes, but they don't like being called out on it. All this has changed under Trump, by the way. And I'll get to that in a moment. But since the early 1980s, the US was instrumental in pushing Mexico to accept the establishment of the UNHCR. Mexico was not a signatory to the Refugee Convention at that time, to establish refugee camps in southern Mexico, which I spent a bit of time in as a journalist back in the early 90s, mostly for Guatemalans, some for Salvadorans, putting all kinds of movement restrictions on, specifically on Salvadorans and Guatemalans, so that even if they were allowed into the country, They had travel documents that did not allow them to travel to the US-Mexico border region. Lots of checkpoints in those areas, and using various kinds of racial profiling, basically, to try to ferret out who was Central American. There's a long history of that I can speak of. But moving closer towards the present, the U.S. has been financing deportations of third country nationals from Mexico since the 1990s, moving into the 2000s, and the Plan Merida, the Merida Initiative. The U.S. has financed a lot of enforcement capacity in terms of digital databases, scanning equipment, training officers, providing Zodiac inflatable boats, all kinds of equipment and training to enhance the control capacity of Mexico in this space. And under Trump has really ratcheted up the diplomatic pressure to an unprecedented extent. What's unprecedented here is not so much what's actually happening in Mexico. What's unprecedented is that the US government is so openly talking about it and so openly pressuring the Mexican government to do what it wants. Interestingly, in Mexico, if you go to the southern border, it's about a 1,000-kilometer border with Guatemala and Belize, it doesn't look like Mexico is a buffer state. It's almost risible. It looks like a joke because you can just go back and forth across the border and no one will stop you. You can stand at the official border crossing and see people openly crossing on rafts, or out in the jungle, people are walking back and forth. It seems like there's no control whatsoever at the border. But what Mexico has is what they call in Spanish a vertical frontier of controls on the transportation routes, trains, highways, domestic airlines, heading to the US. And that's where the control happens. And it's been happening for a long time. So if you look at the major three Central American nationalities that are affected by these processes, Guatemalans, Salvadorans, and Hondurans, this shows you that in blue, this is people of those three nationalities deported from Mexico, and in red, deported from the US. So you can see that for most of this period, the Mexican government has actually been doing the lion's share of these deportations. Mexico doesn't use ugly words like deportations anymore, or detention centers. They use euphemisms similar to the euphemisms that the US uses about any kind of common sense understanding of deportation and detention. That's what's going on. So there are limitations here, and I think some of these limitations are growing. One is that it looks bad internationally and in domestic audiences in places like the US if the full military might is used to control civilians. And there are political entrepreneurs, say, within the US who have taken on this issue. Lots of organizations have taken on this issue. I think more importantly is that within Mexico, there is a much denser civil society around these issues now than there was in the 1980s. There are all kinds of organizations that are monitoring what's going on, that are interviewing people in transit, that are recording abuses and then making that information known at a national level in Mexico and then kicking it up to the international level and to the US media. None of that was happening in any serious way back in the early 1980s. So that's one shift, and you can see a similar shift, maybe not to the same extent, but you can see a similar shift in some other buffer state contexts around the world. And also these issues of transit migration have been linked to, for example, Mexican migration to the US, which has historically been of a far greater magnitude than transit. That's changing now just in the last few years. But the Mexican government, on the one hand, it has passed these laws of migration and asylum that are extremely progressive, that are explicitly written in terms of rights obligations. They're beautiful. And they have done that explicitly in large part because they want to show the Americans that Mexico is taking a high road, and the Americans should take a high road when it comes to the treatment of Mexicans in the US. But then on the other hand, if you look at actual practices, almost all of those are violated systematically in some pretty ugly ways. So these issues have all become linked. All right, the final, just winding up here, the final set of techniques that I'll talk about is the Barbican. And in the US, we don't have a lot of medieval castles, although there is one in Central Park, kind of. So let me just refresh our memories of what a Barbican is historically. So a Barbican is this fortified gatehouse at the entrance to the castle proper. And I think it's a useful metaphor because it points to the ways that governments play with the exact margins of their territories and create sometimes physical structures, as we see in the US-Mexico border, as well as conceptual structures in these liminal spaces around where exactly their territories begin. And there are several different versions of this. So one is in international airport transit zones. Edward Snowden made these famous and quite well known when he was in the transit lounge in Moscow, right? So he was neither, in some ways he wasn't really in Russia, even though he was in Moscow, which is in the middle of Russia. And then that's not idiosyncratic. So around Europe, including in Paris here, an asylum seeker has fewer rights inside these international airport transit lounges, inside this detention center in Charles de Gaulle Airport, than if they were on the other side of the fence. And there's some important court cases around this going back to 1992, but nevertheless, it's still the fact. You have fewer rights in terms of access to translators and lawyers and appeals and so forth if you're inside that lounge than if you're on the other side of the gate. The Australian government has come up with its own, often is coming up with idiosyncratic solutions. And one of them is this idea of territorial excision, of taking successively larger pieces of Australia and cutting them out from the legal map just for the purposes of asylum policy. What do I mean by that? I mean that originally in these territories here in the Indian Ocean and in pink, Christmas Island most prominently, in 2001 or 2002, the government said that if somebody arrived in those territories by sea and asked for asylum, they would be ineligible for asylum unless they had this extraordinary permission from the immigration minister. And then they would be taken off to one of these offshore processing centers. And then, not surprisingly, the smuggling routes changed and people started landing in this yellow zone. And so the government said, well, if you end up in one of these reefs or islands or territory here in the yellow zone, that doesn't count either, just for the purpose of asylum law, that doesn't count. And then eventually they excised the entire continent so that now if you are an irregular maritime arrival, if you show up in a boat without a visa, you cannot ask for asylum again unless you have this extraordinary permission, which is basically never given. Many countries, picking up the example that Jose also began with, have also played with these restricted rules right at their border lines. So for example, Spain has 2 enclaves in North Africa, Ceuta and Melilla. Some people would consider them Europe's first overseas colonies, but that's not the position of the Spanish government. They consider that Spain. In any event, there are now 3 walls, 3 concentric walls, fences, if you will, around these territories. And so originally, you would have an asylum seeker coming here, climbing over the first wall, landing in this space here, and saying, aha, I'm on Spanish territory. I would like to ask for asylum here. And so the Spanish government moved the goalpost, almost literally, and they said, well, that doesn't count. If you come over the first wall, then you're not really in Spain for the purpose of this. You have to have entered all 3. You have to have climbed over all 3 walls in order to be in Spain. And so people started doing that, and so they moved the goalposts again. And now, to apply for asylum in one of these enclaves, you have to go to a particular office in this one spot in the fence. And access to that office is controlled by the Moroccan government. And the Moroccan government will not let you pass if you're of most nationalities. So effectively, using a combination of buffer techniques and the Barbican, they have sealed off what used to be a means of entry into the EU. A number of countries, Israel has also done this, have said that there is a strip of land near the border, and if an asylum seeker is within that strip of land, sometimes there's a time qualification within a certain number of hours of having crossed that they can't ask for asylum in that strip of land, which later, after 2016, was extended to the entire country, but originally was 8 kilometers long. So what are the limitations here? Well, the courts have limited the use of these kinds of spaces, but as I said before, this is exceptionally weak in Australia. And in all of the cases that I'm talking about, whether it's the US or even a lot of EU member states, Hungary is one of the worst offenders, but it's not alone. All of these kinds of court-derived protections in these liminal spaces have been weakened. So, last slide here. What are the comparative takeaways? One is that I think that the law is a necessary but insufficient condition for protecting the right to asylum. And I think that this vague humanitarian norm of basically a golden rule or working under a Rawlsian veil of ignorance, how would you design a system if you didn't know whether you're going to be a refugee or not, and a norm of providing assistance even to people who are very geographically distant and maybe sociologically, demographically different from oneself. Those kind of norms, which in general lawyers don't like because they're so vague, in some ways they also have a power because they're so basic that they can't be evaded through kind of legal maneuvers. They're also easy to understand. They're easy to deploy in the public sphere in a way that some of the details of international refugee law aren't. So I'm not explicitly not trying to replace hard law with soft norms, but I'm saying that those soft norms have a resonance and can be part of an integrated advocacy strategy in a useful way. The second is that to the extent that transnational advocacy networks can constrain state efforts at remote control, they do this in conjunction with the law. The law is used to expose practices through processes of legal discovery, but most of the major landmark cases, such as the Hearsay case that have been favorable to asylum seekers, drew heavily on the kinds of evidence that were being gathered by human rights organizations and the US State Department and independent journalists and so forth about what's actually happening behind the scenes. So both of those are needed to constrain the state. And then if you look at the different techniques, some of them I think will probably never be seriously constrained. There's some interesting legal argumentation going on, at the philosophical level about controlling or opening up avenues via the air passenger system, but it's very difficult for me to imagine that happening in any kind of serious way because that system is so securitized, whereas the Barbican system is the least securitized, and it's because it's based on this play of space and claiming that the state doesn't have full jurisdiction when clearly it does, that I think that especially the courts can play a very important role in that pushback. So these are the observations that are made, and I look forward to your questions.
Can you give some examples of the publicity campaign sponsored by the U.S. government you said looked like they were coming from local communities?
Sure. Are we taking a round, or what's the...
Oh, okay.
Whatever your procedure is.
Hi, good afternoon. Daniel Naujoks, I'm a teacher at CEPA, and actually a lot of those ideas will be placed in my tomorrow's class. I'm teaching on deterrence policies, so all the students here have a huge advantage in that. And what can you tell about additional cracks in the system and how people who would like to engage in, on the one hand, it's a little glum. It's like, now we have an understanding about the real sophisticated ways how watertight systems keep those asylum seekers who deserve to come actually out. So, but what would you tell students here and other people how they can actually contribute, if they're not already part of Human Rights Watch and others, to furthering the rights of asylum seekers? In terms of cracks, the dome, which, it's one very interesting thing to see that our focus on the walls, right? Walls are so in our face, and we can discuss why walls are limiting, but this dome, which, as Professor FitzGerald said, is so much more invisible and so much more effective, actually, keeping people out. But then there's discussions about humanitarian visas, there's ideas about actually holding airlines accountable and getting away from these laws that say, well, there's a private agent who denies you boarding, but it shouldn't, because you should be able to flee for 1/10 of the money that you spend on the smuggler in the end. So what kind of cracks are there, and how can people amplify those cracks, given that they actually think that asylum seekers shouldn't be repelled?
So those are pretty big questions. Maybe I'll start with these. So first you use the word glum, which is interesting because I know you were there actually when I presented this, a version of this in Paris in December, and the French scholars accused me of being such a Pollyanna-ish optimistic American about this issue. But to answer seriously, I don't, there are some cracks. So let's talk about the aerial dome. So some lawyers in Canada and the EU have been working on this issue of whether or not, in the Canadian case, the Charter of Rights and Freedoms applies to decisions made by consular officers in Canadian diplomatic posts abroad, claiming that they should apply. There are efforts to use administrative law norms around fairness and not making capricious decisions and so forth. There's some work in the EU coming out of the Netherlands also in this. But so these are legal theories, but you don't see court cases that have put them into practice. So what should someone do who is concerned about these issues and thinks that there should be something different going on? It's difficult because these basic decisions are made at the political level, right? So changing the color of political parties is probably the most effective long-term way to do these things. But I do think that, maybe it sounds trite, but I don't think it is. But I think raising awareness of what's actually going on is important, because these strategies work in large part because they take place in the jungle, they take place on the high seas, they take place out in the desert, they take place at night, where they're invisible. And a lot of the most egregious stuff happens in those conditions, and deliberately so, because it violates this humanitarian idea that instead of providing assistance, you literally watch someone drown. So I think that, as students and then as people who are thinking about careers, to the extent that they're part of the larger group of people who are paying attention, I think that is exceptionally important in this area, in a way that's even more important than other areas of politics. Because again, this is a set of strategies that thrives on secrecy. And so making those policies less secret, I think, is important. To answer your question about what kinds of publicity propaganda campaigns does the US have, so for example, there are radio jingles and TV ads in places like Honduras, which show someone who is thinking of traveling to the US, facing these horrific conditions and being cheated by the coyotes and eventually dying in the desert. There are songs about the dangers of the train through Mexico, the beast, La Bestia. There are posters, and all of these are presented as if they're locally made. So they have people with Central American accents. Never in the spots or the posters do you see any reference to the US. And I think it's because of the history of US intervention in those areas that they would be less effective if US sponsorship were obvious. In the case of Australia and Canada and the EU, the sponsoring logos are highly prominent. Everybody knows that the EU is paying for some big billboard in Niger that says, "Don't try to cross the desert." And I think it's because despite the history of colonialism, it's being done by the EU, not by a particular member state who was a colonizer. Even some of these publicity campaigns can backfire, though. The Australian government had a really grotesque campaign of a simulated drowning of someone who had tried to reach Australia by sea. And you have the perspective of the person drowning, where you're gurgling and you're going underwater and then popping back up, and eventually you're underwater and you're gurgling and it fades to black. It's really harsh. And they stopped using that, I think, because it's so grotesque. They went too far. But all of these governments use some version of those campaigns. And there have been some efforts to see if they're effective, and the answer is no, they don't dissuade anybody.
Hello, first off, thank you again for the talk. I'm a CEPA student, actually. And I'm really interested in the role of the city as a humanitarian actor and the ways in which cities can push back against more of these quite awful national, international trends. So I was wondering if in your research, did you come across any city governments or city institutions that were pushing back against some of these barriers, or if there's anything that you saw as a potential for cities to push back against these trends?
Oh, yes, I'm an immigration lawyer. I know it's a vast subject, but could you address your gut feelings about, properly vetting for terrorism and the mass migration?
Mm-hmm. Someone there?
With all these dome, Barbican structures, why bother with the secrecy? I think that increasing part of the new electorate is going to enjoy actually seeing these deportations and this horrible stuff actually happening in broad daylight. So do you think that this will change in the future? And why do we go to such incredible extents to hide something instead of just repealing the law and admitting in broad daylight that we are like this? We are a brutal state that is going to protect borders at any cost.
Mm-hmm. Okay, so let me take this random question. So for cities, so at the level of remote control, cities really don't have a role. But if you look at asylum more generally, cities can have a very important role. So to give you a concrete example, under the Trump administration, a lot of people who had crossed into the US, had asked for asylum, had passed an initial interview with an asylum officer that they had a credible fear of persecution if they were returned, and then were set with a court hearing down the road. So they were being dropped off in the middle of the night without any resources. If you're an asylum seeker, even if you've passed that initial credible fear interview, you don't have access to any kind of government assistance like a resettled refugee would. And resettled refugees don't get much assistance, but they get some. Asylum seekers don't get any, and they can't even legally work for the first 6 months. So what some cities have done, such as San Diego, is to provide shelters where people who were formerly being dropped off at the Greyhound station are now able to go, get some legal advice, have a place to sleep, get some food, and then some of them were able to fly to other destinations in the US to be with family members while they waited for their hearing. So that's very much something that was happening at a city, county, and state level, and that's going to continue to be highly relevant. To answer, I'll skip to your question about why don't governments just be as harsh as they can and as they are? Because I think you're right. A lot of people will cheer. A lot of people would not be scandalized by anything that I've shown here, and they would wonder why there's not more, and how come the harshest possible technique in one of these cases has not been adopted everywhere else. On the other hand, I mean, governments have multiple interests, and there are multiple actors who have different interests within government, and one of those interests is to protect people fleeing violence through refugee resettlement, for example, the fact that we have an asylum system at all. That is where the gap between the system that really does protect a lot of people and the more secret system that is keeping them from ever being able to ask for protection, that gap is kept secret, I think, for that reason. The goal of most governments, to the extent that they have any kind of unified policy, is to bring in controlled numbers of people who have been very carefully selected, and that's always been the case. Which leads me to your question about security vetting. So, security vetting of refugees and asylum seekers has been part of the logic of these processes as far back as there has been an asylum system. So if you look at people fleeing the French Revolution, arriving in England in the late 18th century, there were also these fears that maybe folks would also start promoting revolution in England. If you look at one of the strong rationales that the US government, including FDR, used to limit the number of Jews coming in the 1930s as they were fleeing Nazi persecution, is that they might be Nazi agents, or they might be easily kind of extorted, made to work for the Nazis because they had family members left in Europe. When the Eastern Europeans were fleeing things like the Hungarian Revolution, there were also lots of fears of spies being inserted into those flows. And there was security vetting. It took about 2 months or so of security screening, say, of the Hungarians before they were cleared to be resettled in places like the US and Canada. So security vetting has been with us for a long time. And under the Obama administration, it was dramatically ratcheted up. And it now takes, since Obama, it takes more than 2 years for, say, a Syrian who's at a camp in Turkey, who's going to be resettled to the US, to pass through layer after layer of security screening of all the different possible agencies you can imagine before they can ever come. And that's, I mean, security screening is effective. And it's why I don't think there's, the exact statistics are in this book, I don't think there's a single case of a terrorist act committed by a resettled refugee in the US. And we know that in general, the foreign-born population is much less likely to commit crimes, but also political crimes are far less likely to commit political crimes than people born in the US. So I don't think that security vetting is an illegitimate idea, but it's an idea that we have a lot of practice at and quite a strict system in place.
But your book has actual statistics that prove it has been effective.
Yes, and those.
You know, Donald Trump and every Republican and people in the street are terrified.
Sure.
Because he's like, everyone here knows what he does.
Yeah, so the Cato Institute in particular has a report which I cite in the book that is a fantastic analysis, which I can't remember the exact citation, but it's available for free online. Maynai has also seen this. With really strong evidence of different categories of people and who has committed crimes and who hasn't.
Thanks so much for your presentation and for articulating these practices of repulsion and containment. So your presentation makes pretty clear that international law is not the limiting factor on these practices. Most of the examples that you cited come from domestic or supranational courts, or you mentioned norms, media organizations, et cetera. So one of your main theses, I think, is that these norms are most effective at limiting these practices of repulsion. But it seems like the ability to create these norms would be located in the richer democracies that are practicing these efforts to contain people. I'm wondering if you've done any thinking on what countries of origin, mostly developing countries, can do in shaping these norms, and if they can't do anything to shape these norms, whether that's actually an effective suggestion.
Well, actually, I wanted to add something to this, not countries of origins, but countries of possible destination, right? It's very telling that all of these rich Gulf kingdoms, Kuwait, United Arab Emirates, Saudi Arabia, I don't think they have received any Syrian refugees. If they have, it's very few. It's Lebanon and Jordan, right? Although they're countries of immigration, I mean, including Arab workers, right? And not only that, but other places, I don't know, the Rohingyas in Bangladesh, the Bangladeshis in India, all of these Zimbabweans in South Africa. It seems that what you're talking about is liberal regimes that encounter themselves in these boundaries between their ideals and their practices.
Right.
It seems that contradiction or that concern does not apply to countries that do not have this notion of themselves as liberal democracies. Is that well, the two
yeah,
questions?
Yeah, so they're great questions. So let me, maybe we can start with these two before I forget them. So, to answer what I understood your question to be, there's some of the most dynamic areas of the law, which I didn't talk about at all, and important cases are actually coming out of the non-global north countries in this area. So very importantly, the High Court in Papua New Guinea ruled that what was going on in Manus Island was de facto permanent detention, and that violated the constitutional guarantees of people in Papua New Guinea, even if they weren't Papua New Guinean, even if they weren't citizens. So that was an extremely important court decision that, that led to the opening of those camps, and there's a long story about that. There's still all kinds of problems. But that was a decision from the High Court in Papua New Guinea, which itself is the creation of the former Australian colonial master. But that court has taken on a life of its own and has imposed these restrictions on, this has always been an Australian-financed and directed operation. We can see with the Safe Third Country Agreement, which should be in the quotation marks, that the US has tried to impose on Guatemala. That's the Guatemalan Constitutional Court saying that an outgoing president can't simply have an agreement that he signs by himself with the US government, that Congress has, in Guatemala has to approve that. You can see the High Court in Argentina has also pushed back against some of the more restrictive executive actions there around immigration. So it's a great question and an important research area to better understand these sources of law that are coming out of countries that are not in the global north. In terms of your question about other Arab states and their role, so the UAE, for example, has 100,000 Syrians, they say, in the UAE, but none of them are registered refugees. And so they're considered guests, meaning they're workers. It's not really clear how many of them came after the war started and how many were already there working. What the UAE does is basically what the global north countries do, which is to send money now to the UNHCR and also to directly sponsor one of the, by all accounts, nicest camps in Jordan, is the Emirati camp in Jordan. But the other states, you know, often very wealthy states in the GCC, have done very little in this area. So, you know, and then to get to your broader point about illiberal states or kind of hybrid states, they, you know, they're less concerned about territorial rights of personhood. They don't necessarily care if someone touches their toe on the other side of the river because they can simply be expelled. And they also typically don't have the capacity for remote control. They don't have the capacity to put airport liaison officers in the world's airports the way that the US and the Australians and Canada and the EU do.
David, thank you for your talk, and I look forward to reading your book. I'm wondering, with respect to the various techniques that you've outlined for the asylum bubble, I'm wondering if countries that are in the European Union that have a system that they work on together, with some discretion, of course, I'm wondering if they have less mobility to be able to effectuate these techniques in comparison to, say, the United States.
Hi, I wanted to know if there is quantitative data that proves or disproves that these deterrence policies work, because I'm thinking about the Mexican case and the US, and there have been like the Remain in Mexico policy where numbers went up, and then with a 90 days agreement, numbers went down, but I think that migration will keep up. And why haven't governments thought about another solutions if these aren't or are working?
I actually have 3 questions in total. First, sorry. Yeah, first, what's your view on North Korean asylum seekers being ordered to getting their application denied on the basis that they're also South Korean citizens and being ordered to go to South Korea instead? Secondly, what's your view that you showed a diagram of different countries' contribution to UNHCR, and Japan actually in that diagram contributed a lot despite accepting only 0.1% of all asylum applications. And third, what's your view on indirect refoulement by applying this safe third country clause in the law? Thank you.
Okay, so yeah, maybe we'll start with a few of these. So about the nationalities. So yeah, so in many places, in many countries, if a North Korean asylum seeker asks for asylum, the decision is negative, it's rejected, because the argument is, well, they have access to South Korean nationality, although if they go to South Korea, they'll be held for a couple of months in this kind of vetting / re-education and welcome to South Korea program. I mean, that's actually consistent with longstanding practice. That doesn't mean it's a good thing or a bad thing, but the idea that people have another nationality that they could avail themselves of for protection has always been used to limit who gets asylum, and it's not inherently objectionable to me. I think the devil's in the details, but that's a principle that's been around for a long time in many different kinds of contexts. In terms of your question about the Remain in Mexico program, and are these kinds of policies real deterrents in the first place? We know that particular pieces of these policies are not deterrent. So the publicity campaigns have zero deterrent effect, no surprise. But most of them do have a deterrent effect, especially when it comes to air travel and crossing large bodies of water. What's the exact number? It's really hard to argue. Hatton, economist, says that it's something like, I don't know, a 14% reduction of people going to Europe in the mid-2000s based on these techniques. But it's really hard to argue the counterfactual. If you could get on a plane which cost a fraction of the cost of a smuggler, if for $300 you could fly from Beirut to Paris, how many more people would come? I mean, we can think about it, but nobody knows. But I think that there is a general deterrent effect. It shapes who travels. It means that the people who travel are more likely to have money, or they know someone who has money. It means that people who were able-bodied are more able to travel along these distances that involve a lot of physically arduous passages. So it's often that able-bodied men are the ones who dominate these flows. Rather than women and children in particular routes like the central Mediterranean, which then has an effect on the public discourse because the public sees a bunch of men arriving. People generally are socialized to be more fearful when they see a lot of men arriving, especially men with other men, and so then that generates a greater discourse of fear. And I mean, I've studied the issue of deterrence a lot in the context of Mexico-U.S. migration, and for years argued that there was very little deterrence of people who wanted to actually go and who tried to cross. But for those who were thinking of crossing, that U.S. policies beginning in the mid-2000s started to deter people from even trying. And we have evidence of that from our surveys. And what deters people is not being arrested. What deters people is being killed in the desert, or women being raped, or just running out of water and dying. So it's physical risks that have a deterrence to the extent that there is a deterrence. And then Neil, remind me briefly of your question. Sure. Oh, right, in Europe. Yeah.
Is there liberty for those EU countries, although they're in one system and do have some discretion, is there more liberty for them to employ the barriers, the techniques you mentioned, say in comparison to the US?
Yeah, so in Europe, the general story going back to the very early 1990s has been that member state governments, and specifically the executives within member state governments, have changed the level of policymaking to get around various national constraints. So to get around the constraints that the diplomats don't like a lot of these harsher policies, the ministries of justice would try to push all of this up to the European level. Or to get around the constraints of national judiciaries or national NGOs, nationally organized NGOs that were looking out for migrant rights and so on. They would push all this up to the European level. So for a while, that meant that at the European level, you saw many more restrictive things happening than what you did at the national level in places like Germany and the UK. And I argue in the book, though, that over time, the national advocates shifted their operations to a more European level and then beyond level. And so then they have started to have inputs into that process at the European level as well as the national governments. If you look at the effects of the EU and Europeanization just generally through different mechanisms on policies, in some ways it encourages more remote control, mostly using legal techniques of remote control, of designating safe countries of origin, safe third countries, safe European third countries. A lot of these the efforts to have buffer countries criminalize irregular migration, things like that. The EU has been very prominent in doing that. But then the fact that you have all EU member states are also within the jurisdiction of the European Court of Human Rights makes them vulnerable to constraints from that level. So, it depends on the level of, or rather, that's the specific domain of remote control that's being applied as to whether or not Europeanization is increasing it or decreasing it.